Hello, everyone. So this is a law lecture, and it's about judicial review, going into more depths, about it, particularly about what the grounds for judicial review are. Particularly looking at illegality, if the government has acted illegally, looking at the various categories of illegality. We're going to look at what ultra vires is. That's if you act beyond your remit. And then we're going to go look at some extrapolations of the ultra vires issue. Okay, so there was a famous case about General Communications Headquarters in 1984. That's where the UK spies on, emails and phone calls and things like that, somewhere west of London. And it came before Lord Diplock, a very celebrated judge, and he had to consider illegality, irrationality, or he used the word unreasonableness in this case, and procedural impropriety, because you've got to follow the proper procedure, not act unethically when you're doing so. Fairness, he said, comes into this. So there are various reasons why you could claim you need to have judicial review. It could be more than one reason. These can overlap. And he said that the reasons he'd given for granting judicial review are not exhaustive. It's simply an illustrative list. There could be other ones which he hadn't thought of yet. Okay, so there are certain common law standards which are applicable here. And grounds which have emerged since 1984 is a legitimate expectation, that well-known legal doctrine, and also proportionality. Even if the government is doing something it should do, but if it's doing it disproportionately, then that wouldn't be allowed. And obviously the provisions of the Human Rights Act 1998 are crucial, probably create rather more grounds. So anyway, Lord Diplock in that GCHQ case in 1984, he said this: by illegality as a ground for judicial review, I mean that the decision maker must understand correctly that the law that regulates his decision-making power and must give effect to it. Okay, so if he misunderstood what it's about, then that would be illegality. Or if he understood what it's about but didn't give effect to it, did something which was not right according to what his authority was, then that would also be illegality. So let's look at the various kinds of illegality you can get, and really there are 5. So the first one is ultra vires, which is just straightforward illegality. This is beyond what you have the authority to do. Okay, I'm just trying to think what it would be if, like, the Minister for Education issued an edict saying nobody's allowed to speak Spanish in the UK. Well, he's not legally empowered to do that. Another one is errors of law, and judges too can err in law. They've just misunderstood it. They've misapplied the law. The third one is errors of fact. They believe something to be the case, but they're wrong. Now, when so coming on to number 4, abuse of discretion. Now, I think when Parliament was prorogued, this was it, really. And remember, September 2009, the Supreme Court ruled that to be unlawful. This is an example of judicial review. Whether there were irrelevant considerations, or whether things which were relevant weren't considered, or whether something was done for an improper purpose. When the executive chose to prorogue Parliament, they misled the Queen, and it wasn't for the rightful purpose, and therefore non est factum. It was as though she hadn't signed that. And obviously nobody blames Her Britannic Majesty. She just acts as her minister's advisor. It's a Privy Council meeting in Balmoral, a private estate in Aberdeenshire. Jacob Rees-Mogg and others flew up to meet her. She has a weekly Privy Council meeting, and the ministers always stand to do this. The Queen sits. They're not offered any drink whilst they're doing it. Queen Victoria came up with this custom to make them come to the point and do it reasonably quickly. And the 5th ground for illegality is retention of discretion. If discretion has been limited unduly, then that would be illegal. Or you've delegated discretion. You're someone in the executive, and you've given discretion to somebody who shouldn't have it. That should be your judgment call, and you're more or less abdicating a responsibility. So let's look at true ultra vires in more detail. So there was a well-known case, Attorney General and Fulham Corporation, 1921, and it was ruled that this was outside the 4 corners of the Act. Okay, if you're given certain authority to do whatever it is, but you go beyond that authority, that'd be ultra vires. It's not within your gift to do that. However, what if the action taken is incidental to a power which is legally possessed by someone in the executive? Then it might be allowed. That's tricky. There's a case about this Westminster Corporation and London and North West Railway, 1905. Okay, so let's look at this principle of legality. This is statutory interpretation. So how do we understand the statute law, the Act of Parliament that's been passed? Well, there was a case where this is very pertinent, which is R and Secretary of State for the Home Department ex parte Leach in 1994, or ex parte Sims 2000, or indeed R and Lord Chancellor ex parte Witham in 1997. So another thing about erring in law. The person who made the decision might have misinterpreted the law and therefore acted wrongly, and that would be illegal. So anyway, the thing we have to ask is, are jurisdictional errors of law reviewable? And it's decided they were reviewable. That was in as Minnick Limited and FCC 1969. So errors of law. How can we confirm or dismiss this? Well, there's a case about this, which was R and Lord President of the Privy Council ex parte Page, 1992. So it confirmed that all errors of law can be reviewed, not only jurisdictional ones, and that was by Lord Brown Wilkinson, a law lord. So remember, we had the law lords functioning as a judicial, as the Supreme Court before the Supreme Court was founded as such. Remember, the Constitutional Reform Act, I think it was 2004, set it up, but it only actually came into being the Supreme Court as such in 2009. Prior to that, we say the House of Lords, we only mean the judges in the House of Lords, not all the hereditary peers, not all the life peers, not the Anglican bishops. So the Privy Council, as I said, meets the Queen once a week. Anybody who's put into the Cabinet is a member of the Privy Council, and they put Right Honourable before their name, and you remain a member of the Privy Council for life unless you disgrace yourself. Long after you leave the Cabinet, you're still in the Privy Council. The Privy Council, therefore, there were hundreds of members, roughly 12 to 25 Cabinet Ministers at a time, and most of them only last a few years. Now, they sometimes swear in other people into the Privy Council, for example, the leader of Her Majesty's Most Loyal Opposition, sometimes the leader of another party, such as the Liberal Democrats or the Scottish National Party, and you can get some things on Privy Council terms. We're telling you this secretly, and you mustn't tell anybody else. Like in the run-up to the Iraq liberation in 2003, Charles Kennedy, then Lib Dem leader, he was briefed on Privy Council terms, I presume to try and change his mind to vote for the liberation of Iraq, as in he couldn't divulge what he was told. So the Privy Council, they never all get together because there are hundreds of them. Jonathan Aitken was a Conservative minister, and he resigned from the Privy Council about 1994 because there was a cloud over his reputation, allegedly taking bribes. Anyway, and come back to errors of law. There are 3 exceptions to this, where it is not unlawful. If there was an error, but it was not determinative of the decision, all right? So yes, there's an error in law, but it was actually trifling. This is like de minimis non curat lex. The other exception would be if there's a special system of private rules which apply. That came up in Ex parte Page, 1992. Or indeed, when a power is granted and it could be interpreted broadly. So it's might be within that broad discretion. And a pertinent case to this was R and Monopolies Commission, ex parte South Yorkshire Transport, 1993. It's about buses, really. Okay, let's look at errors of fact a bit more. So there could be a precedent fact, there could be a no evidence fact. You think there's a fact, but there's no evidence to prove something's true or indeed false, or there could be an established fact. So we have to be careful about challenges which arise from factual disputes, because these could be beyond judicial control. Sometimes it's difficult to establish what the facts are, and we have to have separation of powers. Remember, the judiciary are very loath to be dragged into the political arena, just as politicians should keep their noses out of judicial affairs. All right, so let's look what a precedent fact is. This is about ministerial power, for example, about a certain park. Was it really a park? So was it a garden or a leisure ground or what? This was in White and Collins against Minister of State for Health in 1939. Dispute about whether they really were talking about a park. What's the proper designation of that? That was considered to be an issue of fact and not of law. Okay, another thing is, well, there are no evidence facts. Well, that's when there is something which is found to be a fact, but it's not proved by evidence. So that might not be true at all. It might not be a fact. Colleen Properties and Minister of State for Health, 1974. That's a case where this came up. So There was Mahon and Air New Zealand 1984, and Lord Diplock ruled on this, and he had the following to say about it. A finding of fact must be based upon some material that tends logically to show the existence of facts consistent with the finding. So notice that was fairly weak language. It doesn't have to prove it absolutely. Probability can be enough. Anyway, then there's another case where something could be illegal and blocked under judicial review if there's a mistake of established fact. For example, there was Secretary of State for Education and Tameside, 1977. In this case, Carnwath, Lord Justice, as in he was head of the Civil Division, he ruled on another case, which was E and Home Secretary 2004. And this is what he had to say. He said, in our view, the time has come to accept that a mistake of fact giving rise to unfairness is a separate head of challenge in an appeal on a point of law. Okay, so point of law and point of fact are not the same thing. Well, E and Home Secretary. In that case, it said there are 4 factors which need to be demonstrated in order to show the necessary unfairness to strike down an action by the government. There could be a mistake as to an existing fact, or indeed the fact that the so-called evidence hasn't been proven, or it could be the applicant is not responsible for a mistake. There is a mistake, but not the applicant is not the one who made it, or perhaps there's got to be a mistake that played a material part in the decision that was made. If there was a mistake, but it was very unimportant, or it just had no bearing on the decision was made, well, that doesn't mean that the decision was made unlawfully. Okay, so exercise of statutory powers. Parliament has statutory powers. It passes statutes, and then it can empower the executive or various next steps agencies to do things, governmental and quasi-governmental acts. There are mandatory factors, there are prohibitory factors, and there are discretionary factors. Remember, you can exercise your discretion. There's more than one way to skin a cat. The government could do this, could do that. They could both be lawful, but he must exercise these decisions lawfully, must be doing so in a disinterested manner, not being overly partial, things like that. There was a case about this, R.N. Somerset County Council ex parte viewings in 1995. So we can see how discretion could be abused. Yes, that you have authority to decide this or that if you're a government minister, for example, but you can't be doing it in a way to, say, lie your own pockets or something, or being unfair, or using discretion in a racist manner or something like that. The court could say that there has not been they've not taken things into account that they ought to take into account, because sometimes, yes, you have a discretion, but you must make your decision on the basis of whatever, the health of the economy or the educational needs of a child or something like that. So a court might say that the person has considered something which is not germane to the issue and made their decision on that basis, about just who I like or whatever, or who's going to pay me or something. That would be unlawful. So what examples are there of abuse? For instance, Robertson Hopwood 1925, or Bromley London Borough Council against the Greater London Council in 1983. So Ken Livingstone was leader of the Greater London Council back then. He was a far-left Labour politician, and there was no Mayor of London as such. There was no London Assembly. It was the Greater London Council was the precursor to the London Assembly, and he introduced a policy called Fares Fair to subsidise bus fares to keep them very low. And anyway, it eventually went over the House of Lords, and it was held to be illegal. Okay, so he'd abused his discretion in bringing in this policy. I don't remember the particulars. There was R.N. Home Secretary ex parte Venables 1998. This was Alan Sugar and Terry Venables in a dispute over, I think, Tottenham Hotspur football team. I don't recall the particulars. All right, let's look at improper purpose. If you do something and it's not for the right reason, the statutory powers have to be used for the reasons that are specified in the statute, saying we're giving whichever government minister, for example, powers to do various things, and the reason he has this is to promote public health, for example, or to make sure national defence is strong. Okay, so if he makes a decision about the armed forces, for example, but his motive is not to strengthen defence, it's just to make money for his cousin or something like that, or to be nepotistic, that wouldn't be acceptable. So Padfield, Minister for Agriculture 1968 is a case in point, or indeed ex parte viewings 1995, which I already mentioned, Congreve and Home Office 1976. Okay, The Minister of Agriculture, one thing, it was about the milk marketing board, because some milk was bought and the government was involved in it and trying to transport it and persuade people to buy it. Okay, so ministers still have a wide degree of discretion on certain issues. Difficult to function without it. We can't have Parliament voting on every little thing, or committees on every little thing. Anyway, so a minister shouldn't limit his discretion too much. Difficult. It can't be too broad, can't be too narrow. Tricky, I know. There was RN Secretary of State for the Environment, ex parte Brent, London Borough Council. That's a 1983 case. Or British Oxygen and Board of Trade, 1971. Notice this were two emanations of the state clashing, because British Oxygen Board was a state-owned company into the 80s. Remember, until the Thatcherite privatisation in the 1980s, there were loads of state-owned companies. Anything with the word British in the name, BHS, that's British Home Stores, British Telecom, as in, phones, telecommunications, British Gas, British Rail, British Leyland, more. Okay, so sometimes they can squabble different state agencies. So Aaron Walk's company, ex parte Collymore, 1995, or indeed ex parte Fire Brigades Union in 1995. So we can see how discretion can be delegated. In Lavatory and Housing Committee, 1970, there was also statutory delegation, and that's under Section 101 of the Local Government Act, 1970. There's the Carltona Principle, 1943, to be borne in mind. That has a decision has to be made by the person who's authorised to make it. Sometimes the decision is made, could be a lawful decision, but it's made by the wrong person, which makes it unlawful. There was R and Secretary of State ex parte Olad Hinde, 1991, about this. Okay, so in future we'll look at unreasonableness and irrationality. Toodaloo.